Many businesses have contracts with suppliers to provide the materials necessary to keep business running smoothly. But what happens if a supplier decides to stop producing the materials contracted for? A supplier's liability for breach of contract is what we explore in Feld versus Henry S. Levy and Sons. Henry S. Levy and Sons, a wholesale bread baking business, entered into a contract with Feld to sell bread crumb, a product manufactured from stale and imperfect loaves. The agreement was an output contract that required Levy to sell and Feld to purchase all crumb Levy produced as a result of its bread-making operations. Each party could cancel the contract by giving 6 months' notice. After selling Feld over 250 tons of crumb in the first 11 months of the contract, Levy concluded that the crumb production process wasn't economical and stopped production without attempting to obtain equipment that would increase efficiency. Levy offered to resume crumb production if Feld agreed to pay a higher price. But when Feld rejected the new pricing, Levy started selling its unprocessed stale and imperfect loaves to animal feed manufacturers. Feld sued Levy for breach of contract. Levy argued that it wasn't liable for breach because the contract didn't require Levy to produce crumb. Rather, the contract only obligated Levy to sell to Feld any crumb that it did produce. Feld filed a motion for summary judgment on the issue of Levy's liability, and Levy filed a motion for summary judgment seeking dismissal. The trial court denied both motions for summary judgment, and the New York Supreme Court, Appellate Division, affirmed. Feld appealed to the New York Court of Appeals, the state's highest court.